Well, the big news of the day today in the Karen Reed case is that Trooper Michael Proctor has formally been dishonorably discharged and terminated, and that finding came out today. So the question that is looming in everyone's minds is whether this finding is going to be admissible into trial. And that's exactly what we are going to explore in the video today. So let's start with the rules of evidence. That's what we have to start with. We'll talk about some case law, and then ultimately, I'm going to be giving you my opinion about this specific issue. Now, again, what Judge Cannoni rules is a different question, but I'm going to be walking through the law, which I believe supports my conclusion in this case. So let's start with the rules of evidence. This is 607. Who may impeach a witness? Any party, including the party that called the witness, may attack the witness's credibility. So even if you call the witness, this is my witness, but I want to attack that witness's credibility, you are allowed to do that. However, the party who calls a witness may not impeach that witness by evidence of bad character, including reputation for untruthfulness or prior convictions. So Hank Brennan's probably looking over this rule now and thinking in his head, wait a minute, I have an idea. Maybe I won't call Trooper Proctor. If I don't call Trooper Proctor, then look at the second part of this rule. The party who calls a witness may not impeach the witness by evidence of bad character, including reputation for untruthfulness or prior convictions. So maybe the Commonwealth is going to posture and they're going to say, you know what, we're not going to call Trooper Proctor. If the defense wants to call Trooper Proctor, well, then that's fine. But guess what? They're not going to be able to impeach Trooper Proctor by evidence of his bad character and bad acts and findings that were found because of his bad acts. That may be going through their minds. Now, let's just go through that possibility. Let's say Commonwealth does not call Trooper Proctor. So for number one, is the defense does not have to call Trooper Proctor. They can just continue with their case without calling Trooper Proctor. And if they do, think about the argument that they can make to the jury in closing by telling the jury, you know, the Commonwealth is so insecure and unsure about this case that they are not even calling the lead investigator in this case, the lead investigator who was responsible for charging Karen Reed and making her sit through this 30-day trial. They are so not confident with his ability to testify and say the facts as they are that they didn't even call him in this case. That's a pretty strong argument right there. But I think the good money, if I was the defense, I would definitely call Trooper Proctor because you want some of those text messages to come out. You want some of his actions and conduct in this case to come out. So now if you're going to take that avenue, which I think is the better avenue to take, actually call Trooper Proctor if you're the defense, how are you going to get around this rule? Okay, so that's first problem we have to deal with. Let's move on to another rule. This is another rule. This is 608. A witness's character for truthfulness or untruthfulness. And we'll go to 608B. Specific instances of conduct. In general, specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking the witness's credibility. So here's another problem that the defense has if they want to call Trooper Proctor. And again, if the Commonwealth is not calling Trooper Proctor, so then here is, even if the Commonwealth does call Trooper Proctor, you're going to have this problem. In general, specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking the witness's credibility. And the same would also apply if you're trying to show misconduct to show that the witness is just a terrible person, just attacking his character. So again, these are not admissible, generally speaking. So how is the defense going to get around this? And is there a way around it? Maybe there's no way around it. And maybe you're right, they're stuck. And this is not going to be able to come in. The finding specifically is not going to be able to come in. So now we have to go to some case law. So this is the case law that interprets these rules and defines these rules. So let's go to the Commonwealth versus Lopez decision. Okay, now let's look what happened in this case. I'm not going to read through the entire case, but we're going to go through the important parts. The defendant contends that the judge erred in not allowing the defense to cross-examine Officer Williams, one of the prosecution's key eyewitnesses, about an internal affairs investigation. Wow, so sounds very similar to this case. You got this Officer Williams who took the stand, and the defense wanted to cross-examine this Officer Williams about an internal affairs investigation. The defense wanted to bring this up, and the judge says, sorry, you cannot bring up that internal affairs investigation. Specifically, the defendant sought to impeach Williams with information that the Boston Police Department had suspended him 5 years earlier for, among other things, lying in an internal affairs investigation on a personal matter. So this, again, had nothing to do with the specific investigation that was tied to this case, to the Lopez case, but they wanted to bring in this this internal affairs investigation about a different case or some other conduct that this Officer Williams engaged in. And they wanted to bring that up and to impeach Officer Williams when he was on the stand. And the judge did not allow it. And that's why they're appealing it. And this is why we have this opinion. So what happened was 5 years earlier, we conclude that there was no error, as the judge was well within his discretion to exclude this 5-year-old evidence of lying. Okay, so not looking so good for the defense if we stop right there. But let's continue with this opinion, and then maybe we'll see that there's actually some exceptions. So here we go. In general, specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking the witness's credibility. And they cite some law in some cases. Here, Officer Williams' alleged conduct from an internal affairs investigation 5 years before the murder was not material to the May 30th, 2010 homicide investigation. Oh, okay, so let's stop right there. What's the reason that the court is giving? Not because you just can never introduce misconduct to show that the witness is being untruthful or otherwise. It's because that this internal affairs investigation 5 years earlier was not material to the May 30th, 2010 homicide investigation, which is the subject of this case in Lopez. That investigation did not result in a criminal conviction, so there's no conviction there, or even a criminal charge. It was also not related to how he conducted police investigations. This was a personal matter. It was a personal matter, nothing to do with how he conducts investigations. Thus, it was well within the judge's discretion to conclude that any probative weight of such 5-year-old evidence was far outweighed by the risk of distracting the jury with the details of an unrelated incident. So the reason why, very clearly in this case, this was not found to be an abuse of discretion is that in this case, this internal affairs investigation had nothing to do with this case. It was a personal matter, which he lied about. And it was also 5 years before. So that's why this opinion, in Commonwealth versus Lopez, this opinion, they found that there was no error here. There was no abuse of discretion to not allow this information to come in, to not allow the defense to cross-examine Officer Williams about this specific internal affairs investigation. It was not considered an abuse of discretion. Again, why? Because it was too far back, 5 years before, and the internal affairs investigation had nothing to do with this case in front of them. All right, now let's move on to another case. This is Commonwealth versus, I got to get the name right. Let me go back all the way to the top. We got Commonwealth versus Bohannon. That's how you say that, Bohannon. So now this is a very sad case. If you want to read the entire case, it's pretty bad, but we're not going to read the entire case. But let's get to the actual holding of the case. And again, talking about prior bad acts. In general, evidence of prior bad acts may not be used to impeach a witness's credibility. That's the starting point. Okay, so let's understand that is the starting point, that in general, this type of evidence is not going to be admissible. But here we go. One clear exception to this general rule is that records of criminal convictions may be used to impeach credibility. Okay, so you are allowed to introduce records of criminal convictions. Okay, well, is this going to be considered a criminal conviction? It's going to be hard to argue that this is a criminal conviction. This is just a trial board finding about Trooper Proctor. Okay, but let's go on. Evidence of prior false allegations has been excluded as a consequence of this general rule. In the Miller opinion, however, we indicated that the rule was not inflexible and that there might be cases presented in which such evidence might be competent. We conclude that this is such a case. When evidence concerning a critical issue is excluded, and when that evidence might have had a significant impact on the result of the trial, the right to present a full defense has been denied. So here we are finding already an exception to this general rule that evidence of prior bad acts may not be used to impeach a witness's credibility. So again, what is it? It is that when you have evidence concerning a critical issue is excluded because you did not let this evidence in. And when that evidence might have had a significant impact on the result of the trial. So are those two things true in this case? When you have Trooper Proctor's conduct and his actions and the findings of those actions, So are those critical issues in this case? Of course, his conduct is a critical issue in this case. Of course, his conduct and his text messages and the way that he conducts investigations are a critical issue, specifically when we're talking about the investigation that he did in this case, right? That's definitely a critical issue. And it's definitely could have a significant impact on the result of the trial. So already you have an argument that under this Commonwealth versus Bohannon, you can argue that definitely this fits into the exception of the rule. So again, we start with the rule, and now we're finding exceptions, and then you're going to have to argue if you're from the defense that this finding actually fits into these exceptions, this narrow exception. So let's move on now to one final case. And that is in the matter of a grand jury. So let's go back just to get you the right name here, to make sure I got the name right. In the matter of a grand jury investigation. So very interesting investigation here. If you want to see about some more corruption, you can take a look at that. All right, let's look at this case. The petitioners also argue that prosecutors have no obligation to disclose the petitioner's false statements because their prior misconduct would not be admissible in evidence at trial in any unrelated criminal case. We disagree. The petitioners are correct that in the absence of a conviction, in general, specific instances of misconduct showing the witness to be untruthful are not admissible for the purpose of attacking or supporting the witness's credibility. A party may seek to impeach the credibility of a witness by means of the court records of the witness's prior conviction or a certified copy. Like we spoke about, if you want to introduce court records or a prior conviction, that you are allowed to do. But in general, like we keep saying, specific instances of misconduct is not going to be admissible. But we have chiseled a narrow exception to this general rule. Recognize that in special circumstances, the interest of justice forbids strict application of this rule. So again, this is a court saying we recognize that you have a narrow exception when there are special circumstances, and when you have the interest of justice, then it forbids the strict application of this rule to not allow evidence of prior bad acts. Okay, let's move on a little bit. Here we go. Listen to this part. A judge has the discretion to decide whether the credibility of a police officer is a critical issue at trial and whether the officer's prior false statements in a separate matter might have a significant impact on the result of the trial, such that the prior misconduct should be admitted in the interest of justice. So, in the interest of justice, does the prior misconduct, and now again, you'd have to argue that it's not limited to a police officer lying, but it also has to do with his conduct in general, or his misconduct in general. So, in the interest of justice, such prior misconduct should be admitted. In Lopez, we concluded that the judge did not abuse his discretion by preventing the defendant from impeaching a police officer who was one of the Commonwealth's key witnesses in a homicide case, with information that the Boston Police Department has suspended the police officer 5 years earlier for, among other things, lying in an internal affairs investigation on a personal matter. Remember, that was the case of Lopez that we just spoke about a couple minutes ago. In that case, remember, the judge did not allow this impeachment material to come in, this internal affairs investigation that happened 5 years prior. He did not allow it to come in. So now this is this case talking about the Lopez decision. And they're saying, in Lopez, we did conclude that the judge did not abuse his discretion. I mean, that was okay for the judge not to do it in that case. We noted that the alleged conduct was not material to the homicide investigation where it took place 5 years before the murder, did not result in a criminal conviction or even a criminal charge, and was not related to how the officer conducted the police investigations. Our delineation of these factors suggests that a judge, in deciding whether to allow a police officer witness in the interest of justice to be impeached with prior misconduct, you see that? They're not limiting it to prior lying or untruthfulness, with prior misconduct, may consider the age of the prior misconduct. How old was it? How many years before did this misconduct occur? And in this case, we know it happened literally at the time of the investigation. The strength of the evidence of the prior misconduct. How strong is the evidence of prior misconduct? And the simplicity of establishing it, and whether the prior misconduct is probative of how the officer conducts police investigations. So is it probative? Meaning, in that issue in Lopez, remember, it was a personal issue. Maybe he lied about some personal taking vacation time or something. It had nothing to do with how he conducts investigations. But if there's something about a police officer's misconduct that actually sheds light on how this police officer conducts his police investigations, well, that's a completely different story. As to the age of the misconduct, if it happened so long ago, so that it would not be admissible for impeachment, had it resulted in a criminal conviction, it would not likely be admissible in the absence of a conviction. Okay, so right away you're seeing from here that these other factors, that these cases are all looking to Lopez, and they're seeing from this case of Lopez that when you think about these other factors, like the ones we spoke about, how close in time it was, and whether it actually shows how the officer conducts police investigations, well, then you're not stuck with this rule. And that would be where an exception would apply. Okay, so that is in terms of this case. And also, you know that I love to talk about footnotes. So let's take a look at this footnote, because this is a footnote talking about the Lopez decision. Remember, the Lopez decision, the judge did not allow this cross-examination to come in about this internal affairs investigation. And the court found that it was not an abuse of discretion. But listen to what this footnote says. We also note that our conclusion in Lopez that the judge did not abuse his discretion in barring such impeachment does not mean that it would have been an abuse of discretion for the judge to have admitted such evidence. So do you see what this footnote is saying? Do you understand the importance of this footnote, which is why it's so important to read footnotes? What this footnote is saying is that if the judge in that case would have allowed that internal affairs investigation to come in that case, in the Lopez case, even though it was 5 years before, and even though it had nothing to do with the actual case in front of them, with the investigation that was done in that case, it had nothing to do with it. It was completely a collateral matter. And what this case is saying is that we're not saying that if the judge would have admitted that, then it automatically would have been an abuse of discretion, meaning it would not have been abuse of discretion. That's what, if you're just reading between the lines, that's what they're saying here. It would not have been an abuse of discretion in the Lopez case for the judge to allow cross-examination about something that happened 5 years before, an internal affairs investigation about a personal matter that had nothing to do with this case and had nothing to do with showing how a police officer conducts his investigations, police investigations. So you see that this court is actually winking and letting you know that if you allow this stuff in, even something that's so off the mark like that, we wouldn't have found that that's an abuse of discretion. Now let's talk about this case. Would it be an abuse of discretion in this case? Absolutely not. Of course not, right? This has to do with the actual investigation that he did, that Trooper Proctor did. So this is basically, essentially, what I find that this court is saying specifically would be no problem to admit this type of evidence in the Karen Reed case. Now let's move on to one other part. Okay, and this is another part which you have to know how to analyze each part of this, right? This is talking about prior bad acts, talking about maybe reputation, character testimony. But what about there's another area in cross-examination which you're also allowed to explore? Okay, you got to remember, keep your ducks in a row, what we're talking about specifically in front of us, and then argue that specific issue. So this is about prior bad acts. This is about character testimony. But now let's take a look at this next rule, bias and prejudice. So this is scope of cross-examination, and I don't see if I have the section. Okay, this is Rule 611. So Section 611 in the Rules of Evidence in Massachusetts. Look what it says here. The scope of cross-examination, bias and prejudice. Reasonable cross-examination to show bias and prejudice is a matter of right which cannot be unreasonably restricted. So if there's anything about this investigation or finding that you can argue shows bias, then this completely has nothing to do with prior bad acts. That doesn't even get analyzed under prior bad acts. It doesn't get analyzed under the past rules and case law that we were talking about. This is a completely different animal. And when you want to show bias and prejudice, the gate is a lot more open, much more wide open than when you're talking about character testimony or bad acts. So, is there anything in this finding that talks about bias and prejudice? And if you've probably seen this already. I'm not going to read the entire finding because you probably have all seen it already by now, but let's just review one part of it. Trooper Proctor, through his actions on various dates between January 29, 2022 and August 17, 2022, did fail to conform to the work standards established for the member's rank, title, or position, and or did fail to take appropriate action on the occasion of a crime, disorder, or other condition deserving state police attention. This occurred when Trooper Proctor, while assigned as the lead investigator in a homicide investigation, through his unprofessional and inappropriate conduct, created an image that he was biased in his dealings with a homicide suspect and or brought otherwise himself and the Massachusetts State Police into disrepute. So what do you see specifically from this finding? This finding is letting everybody know that Trooper Proctor created an image that he was biased. If this is not evidence of bias, I don't know what is. So this part absolutely has to come in. This doesn't even get into the analysis of prior bad acts or character testimony. This is specifically talking about bias. So even if you want to argue that the rest of this should be struck and we should not allow to admit the rest of this finding, okay, fine. Maybe you can argue that. And again, like I showed you, I think that there's a very strong argument that this actually all comes in. But even if you want to give that to the Commonwealth and say that part's not going to come in, this part has to come in because this only has to do with bias. It has to do with his dealings and his showing that he's biased. And that doesn't even get analyzed like we were talking about under the other rules of evidence. So this is why I think definitely this part has to come in. And the other part, I think there's a very strong argument for it to come in. And again, it will come down to Judge Cannoni's discretion, and an abuse of discretion is a very high standard. So whatever she rules in this case, it's going to be hard probably to reverse her on this, but there can definitely be a case, that this should definitely come in from those exceptions from the case law that we went through today in the video. Now, there's just one other point that I'd like to make before we sign off today about this specific issue. And that is that generally speaking, when you're talking about bad acts, you're talking about character testimony, you're talking about character testimony and bad acts that really have nothing to do with the case. That's generally speaking what we're talking about when we're talking about bad acts. Prior convictions. Let's just take prior convictions, for example. What does prior convictions have to do with the case in front of us? Let's say this guy murdered 20 other people before. What does it have to do with this specific case in front of us? And that can taint the jury. Because he has this bad character for murder, so maybe he did this murder as well. The jury's going to think that. So when you're talking about character evidence, the problem with character evidence is that the reason why it's not admissible is because you're just trying to show that this is a person that has a propensity to act in violent ways or criminal ways. So that's generally speaking when you're talking about character testimony. In this specific case, I would argue that this is part of the investigation. This is literally part of the investigation that Trooper Proctor is doing. Anything that he's doing that has to do with the Karen Reed case is part of the investigation. This is not prior bad acts. This isn't character testimony from something else, a personal matter or otherwise, even if it's not a personal matter. We're not even talking about bad character or bad reputation or whatever it is that has to do with other cases that he was involved in. That already, okay, that's more of a gray area, which is harder to get stuff like this in. But here, we're talking about the actions that he took on this specific case. So, of course, it's tied directly with this case. And therefore, any findings that are related to his actions and his investigation that he did in this case should come in. And they shouldn't be barred because of character testimony. Because again, generally speaking, character testimony and reputation and all this stuff has nothing to do with the actual case in front of us. But here, everything that he did that has anything to do with the investigation with Karen Reed should be connected to the case intimately. And therefore, it should be able to be shown in court and to be able to impeach his credibility. And therefore, the findings, again, another reason why the findings should be able to come in for this trial. So that is going to be on the analysis today on the Trooper Proctor stuff. And we are going to see there's a motion, there's a formal motion that was filed today to delay the trial. It seems that it was actually agreed to by the Commonwealth as well. So now it's like a joint motion by the Commonwealth and the defense to push this trial off till at least April 25th. Like I said, I'm not sure if Judge Cannoni is going to grant that motion so fast, but personally, it would actually work better in my schedule. So, I mean, if she wants to take me into consideration, I would definitely prefer the trial to go off at the end of April 25th. We have some Jewish holidays coming up, so it would be much easier for me to cover this trial if it's pushed off to April 25th. But we'll see what happens with that. And there's a number of other motions that we haven't gotten to yet, but there's just so much going on in the Karen Reed case every single day as trials getting closer and closer. You got to sometimes pick and choose, and you can't cover everything. But we are going to do our best to cover as much as we can. So that's going to be it for now, and we will see you at the next video. Keep it here. If you haven't yet, please subscribe, like, and we will see you next time.